it comes to that, it's like an honor. Well, I'm gonna see him off. So if this is the way that he going out, we already made peace.
Has he said that to you, that he's made peace?
Multiple times.
We are now under an hour away from the execution of Marcellus Williams in Bonne Terre. The Supreme Court just moments ago allowed Missouri to proceed with its plan and has just rejected 2 separate appeals. The convicted has maintained his innocence, leading to a host of legal maneuvers. Fox 2's Jeff Brenthal is live outside of the prison right now with what we're learning about those preparations that are now underway. Jeff.
Yeah, Mandy, those efforts, as you mentioned, to spare his life have continued right up until this very hour here. Williams convicted of the 1998 of Felicia Gale. The state of Missouri, though, now moving forward as they prepare for this execution scheduled to take place soon after.
All right, what's up with y'all? So look, man, I'm back again with another video, right? And I'm pretty sure a lot of y'all already done seen this situation take place. I just wanted to speak on it, you know. And a lot of people have been asking me my thoughts and opinions on it and asking me to speak about it and things like that. But really, in all actuality, I've just been waiting on the Supreme Court, because when they say whatever they say, that's really what's going to happen. You know what I'm saying? So look, basically, long story short, you know, this is before the lethal injection happens. I hope it doesn't happen. I hope they do come up with something, but they already came to their decision. I'm going to let y'all watch that as well in this video also. The whole Supreme Court hearing before they actually denied the request to go ahead and grant him clemency, however you want to put it. You know what I'm saying? There's so many different ways you can put this. But basically, long story short, if you don't know what I'm talking about, Marcellus Williams, he actually is in jail right now for the murder of Felicia Gale. I think that's how you pronounce her name. And she was stabbed multiple times, and he's been in jail for that. Now, a lot of evidence is showing right now that he had no DNA evidence there on him at all. So, I said on him, on the weapon. So, with all that being said, the prosecutors even basically said he should be exonerated. He should go ahead and be out, whatever the case may be. They're ignoring that. Now, they just did this to another guy. I'm going to do a video about him as well. But, you know, the reason why I haven't really spoke on it was just because it really don't help to actually just keep on saying certain things on the media about it. I'm more of an action type of guy. Now, when somebody goes missing and certain things like that, I'm always on it. But, you know, when it comes to these type of things, you got to go to the courts. You got to call people. You got to say certain things. I've been texting the hell out of this number that they've been giving out for the petition. You know what I'm saying? And I ain't going to say, I done put in multiple petitions. I'm going to say that. You know, I don't want to mess myself up in no type of way. But I've been trying, and they always just say, what's your name? Different things like that. And it ain't really going nowhere, bro. You know, not saying that you should give up and certain things like that, but I'm just saying that it's kind of hard to get something overturned in the Supreme Court. His son is standing up for him. His son is in his corner, and I really rock with that. He's not giving up on him. He has full faith in his father, which you should do. And I mean, he even stated that him and his father has already talked about this happening, and his father has already like come to grips with his reality. And I hate that, man. You know, and the countdown is now. It's 4 o'clock where I'm at in Texas right now. I probably had this out around 5. I don't know if it's already taking place around this time when y'all see it or whatever the case may be. But I do want to say RIP to him and send my condolences out to him if it did go through. But I hope it didn't, man. You know, it's just sad and unfortunate the way that they doing people, bro. This is really illegal in my personal opinion. You know, you get exonerated. There's no way in the hell it shouldn't be so simple to go over there, write a paper, and get them right on out of jail. You feel me? But it is what it is. Y'all already know how the justice system is. I'm going to go ahead and run some of these videos right now. Like I said before, I do have the Supreme Court hearing that took place. And you'll hear certain things they had to say, and they really wasn't trying to hurt nothing, bro. You know.
How does hope apply to where you are right now in life?
Like, I hope a miracle happens, you know what I'm saying? I hope it's, all I wish is to free my father from abundant enslavement and spare his life.
What would you say to the Supreme Court if you had the opportunity to testify on behalf of your dad?
I would try to make them see that this is a murder on their behalf, and this is wrong, you know? And I believe my father is truly innocent, and they need to take a closer look.
Have you allowed yourself to even get to Tuesday right now?
Yeah, I already put it inside my body that I would be a witness to the execution. I'm standing firm and show my dad he's not alone if this what it comes to, and I'm ready for it. My mindset, my spirit, strong. Like, I'm doing this for my dad. It's bigger than me. So for me to be there in that time, if it comes to that, it's like an honor. I'm gonna see him off. So if this is the way that he going out, we already made peace.
Has he said that to you, that he's made peace?
Multiple times. It's not even just making peace. It's like this is a natural way of life. You're going to die.
Let's get into the video.
Developing tonight, in less than 20 hours, Missouri death row inmate Marcellus Williams is set to die by lethal injection. It comes after the state Supreme Court ruled this evening that the execution should move forward. Brent Solomon is in the newsroom with what will happen from here.
Hey there, Mike. Tonight, the group Missourians to Abolish the Death Penalty tells me it will deliver more than 1 million signatures to the state capitol tomorrow. It's a last-ditch effort to halt the execution, despite today's ruling from the state's high court.
Please be seated.
In Jeff City Monday, a hearing before the Missouri Supreme Court to stop Marcellus Williams' execution 1 day before it's set to happen.
And basically, Mr. Williams is going to be killed because the government mishandled this evidence.
Michelle M.L. Smith was at that hearing and listened as the state's high court ruled against staying the execution. Prior to that ruling, Williams' attorneys insisted there were errors in jury selection for the 1998 stabbing death of newspaper reporter Felicia Gale. They also pointed to what we've heard before, reports of the murder weapon being mishandled.
And the main person who would say the government did wrong, you would know, is Prosecutor Bell. That's his office today. And he looked back at what his office did, and he said, yes, my office messed up.
After the ruling, St. Louis County Prosecutor Wesley Bell saying this: even for those who disagree on the penalty, when there is a shadow of a doubt of any defendant's guilt, the irreversible punishment of execution should not be an option. He goes on to say his office has questions about Williams' guilt and about the integrity of the conviction. Governor Parson denying Williams' request for clemency, saying Monday capital punishment cases are some of the hardest issues the governor's office has to address. He said, quote, when it comes down to it, I follow the law and trust the integrity of our judicial system.
I heard Governor Parson also say that he stands with victims' families, and he does what the victims' families want. The victims' family doesn't want this.
The governor says Williams exhausted due process, saying no jury or court have found merit in his claims for innocence. Tomorrow, Williams supporters will gather in several cities, including at the state capitol. They're hoping the U.S. Supreme Court will step in.
A St. Louis County man.
Okay, so the family doesn't want that. I seen it. I read that before I did this video, right? And for them to still want to do this, there's something that they want to do. There's nothing that you can say to make me not think that they just want to take this man's life. Y'all got to understand and realize, for those who don't, because I know a lot of people do, but a lot of people in high places like things like this. They get a kick out of it. They get their rocks off. You know what I'm saying? It feels good to them. That's why they do this. And I really hate that they are doing this to people, bro, just because they got sick, twisted fantasies. You got to understand that these people have families that's finna watch this. They get an even bigger kick out of your family watching you pass, because they're going to watch them break down. They got bets on certain things like this. Who will pass away the fastest? And everything I'm saying is allegedly. You know what I'm saying? But common sense and a lot of things I've seen, and I'm pretty sure a lot of things y'all seen, can let you know what I'm saying is the truth. They make movies about stuff like this all the time. Not saying that you can put a movie into reality, but y'all already know it's a lot of hidden messages in movies and things like that. But yeah, they have bets on how fast a person will pass, all type of different things like that. So yeah, you got to realize and understand that this is something that's a part of someone's fantasy, because they already know what's up. If you have a magnitude of people around you telling you that this isn't the right thing to do, he didn't do this, or there's no way we can prove that he did do this, why are you not trying to understand that and move differently? Why are you not trying to say, hey, look, I can see where they're coming from. Hold on, this damn thing, oh man, shit. So like, why not say, hey, look, I see where y'all coming from. Let me go ahead and fix my wrongs, or fix the system's wrongs and stuff like that. And I see a lot of people saying we failed you and things like that. We didn't fail them, the system failed them. We've been trying. If you like me, you've been sending text messages. You've been doing your thing, man. You know what I'm saying? It's just sad and unfortunate that a lot of people are passing away because of stuff like this. And it's just pitiful that your family got to watch it on top of that. Let's get back into it, man.
Set to die in less than 2 weeks after a judge refused this morning
This was
to
before.
overturn or set aside his conviction. Tonight, attorneys for Marcellus Williams tell us they are still fighting to keep him off death row. Thanks so much for joining us. I'm Kelly Jackson.
I'm Ann Allred in for Mike Bush. Williams was convicted by former St. Louis Post-Dispatch reporter Felicia Gale. Our Justina Cornell has been following the back and forth legal battle and joins us in the newsroom with the very latest. Justina?
Well, the biggest question right now is what's next? Marcellus Williams may be out of legal options, and his fight right now is against time.
Always a person of immense faith, and he, holds to that.
She's describing her friend Marcellus Williams. Michelle Smith is also the co-founder for Missourians to Abolish the Penalty. She's been pushing for Williams' freedom. The death row inmate has claimed innocence for the 1998 of Felicia Gale.
In today's understanding of the evidence, Prosecutor Bell does not think that this would have been a case that his office would have brought forward or that should have been brought forward for conviction.
However, a St. Louis County judge handed down a decision Thursday. He ruled that Marcellus Williams' death sentence and murder conviction would not be vacated or set aside.
I know that the victim's family, Mrs. Gale's family, has stated that they are against the death penalty.
The judge who made this decision is also the same judge who signed off on an Alford plea a week prior, which would have spared Williams from the death penalty. But the Attorney General appealed the plea, and there was an evidentiary hearing a couple of weeks ago. On Thursday, a judge ruled there wasn't any new clear and convincing evidence, and attorneys failed to demonstrate any basis to find him innocent. We asked one legal expert about next steps.
It seems he exhausted most of those things. Now, but the court has just ruled again, so the question now, does he have any appealable rights after that? Because the court just ruled. I don't know. I think, in my opinion, it's a long shot.
Clemency could be on the table, as it's a race against the clock.
Clemency comes from the governor, state of Missouri, and I'm afraid to say that they may be closely aligned with the AG's office. I think it's going to be very difficult.
I know that people who of faith believe in miracles, and our governor says he is a person of faith.
Williams' attorney said they will continue pursuing every possible option to prevent his execution. St. Louis County Prosecutor Wesley Bell also sent a long statement that said he will continue to work to prevent an execution as well. Now, we've reached out to the Attorney General's office for comment. He has not responded.
A lot of people be saying this and that, what they're going to do, how they're going to prevent it, different things like that. That shit ain't going to work, man. If it's a set of people that can control every goddamn thing, what you going to sit here and keep on lying to us for? You can say, I'm going to talk to them and see how they feel about this. I'm going to talk to them and see what's up, see what I can do. But to say you're going to, well, he did kind of say he going to try shit. I'm just kind of frustrated here. But just keep it real, bro. You know what I'm saying? And it's just crazy that his son got to watch this, bro. Just imagine having to watch your parent pass away over some shit that they didn't do. They will piss, man, boy, what? And then they wonder why people go crazy and do certain things, man, because look how y'all treating and reacting to certain situations. It ain't what's up, bro. This crazy, bro. This crazy, man. Let's get back into it.
No, Mama. Let him do it.
Okay, so what was she referring to? Let me do it. Let me do it.
Well, the beginning of that phone call, when I answered the phone when she called, I didn't know who it was, so I was trying to get to my recorder. That's why you heard her say, yes, get your recorder, let's do this. Because the initial part of that phone call said, at that time my name was Smith. Miss Smith, is it too late? Is he dead? Did they kill him already? Is he dead yet? I got something I want to say. And so at that point I said, can I record you? And she said, yes, get your recorder, let's do this. So I can, from what she said, I'm sorry, go ahead.
So the question becomes, and thank you for telling us about it, Allison, obviously reading through the rulings, that's not good enough. The court and the governor both say, no, we don't know that she didn't do it, and it's not competent evidence, and we've done enough of this. What do you feel about that reckoning?
I feel that is exactly reflective of what's wrong with our justice system today. Why are they in a rush to execute somebody? There's so much evidence pointing towards his innocence that just literally pushing the execution back 3 weeks to hear this new evidence, once he's gone, you can't bring him back.
They don't
Why
want
not
to
just delay the execution and hear all these points?
They say 15 times he's tried to do this, and that this both of these people, the man who's now deceased, who was one of the prison informants who supposedly wanted to recant but never did, and now her, who supposedly wants to recant but never officially did, they say that's not enough.
Well, hearsay does count in the state of Missouri. It actually freed Kevin Strickland last year. Latara, if you want to elaborate on that.
Well, yes, I do know that Kevin Strickland, there were witnesses in his case. And, they were allowed to say what the witness in Kevin Strickland said. So I'm not understanding. And I don't think this has never been presented to the court. So let me clear this up. But I don't understand why come is something that the courts would not consider. Because it most definitely, you could tell she was most definitely getting ready to say something that was against her self-interest. And that is exactly how the state of Missouri, how they were able to answer and do what they did in Kevin Strickland's case.
All right, so one last question. Allison.
Yes.
And how terrible is this, that we're having this conversation and literally this man may be gone tomorrow? And
it's
we may not know
2024.
what the truth of it is. I mean, what a crazy time.
It is a modern day
Allison,
lynching. Yeah.
Well, look, I understand your perspective on it. The counter is, well, but we have a system and there's been so much due process here that he's had more than enough time for this. But what does it mean to you that, again, how do you deal with this, that tomorrow he's going to be gone?
Which is today.
Not good. We went through this a few years ago, and I'm praying we have the same outcome at the 25th hour. We got the stay of execution, and I'm really holding strong that we're going to again. I mean, there's so many things, I mean, we don't have time, but like the knife was contaminated by the state. Like right for that reason, there should be a mistrial or a retrial.
Mm-hmm.
They literally contaminated the evidence, the state of Missouri, that could have exonerated him. How is that fair that he's punished for their own people ruining the investigation?
What does it mean that the Innocence Project, so the Innocence Project has picked up the representation, everybody knows who they are, and they are not advancing this argument that this caller was going to recant. Why not?
I personally believe, and I'm a huge fan of the Innocence Project, they do great work. I know they really focus on DNA, and they have presented the DNA, and they have presented that there were a handful of fingerprints on the knife, and that none matched Marcellus. There were also bloody footsteps leaving the scene that weren't Marcellus Williams' shoe size. So I can't speak on their behalf. I mean, they do great work, and I'm huge fans of theirs,
right.
But I think there's a lot of cooks in the kitchen, and I think everyone's trying to do what they can.
That could be it. But though, to be fair, the DNA stuff was chewed on pretty well multiple times over in review at the trial and appellate level, was found lacking. But we will be watching this. We'll see what happens with it. I wanted to give it attention tonight, Allison, because I believe in what you're doing. And Latara, I appreciate you telling people what you know and understand. They should have eyes on our system. So thank you for coming and taking the opportunity. I wish we could have done more. Hey, thanks for watching. Go to joinnn.com to find News Nation on your screen. And don't forget, click the...
All right, so the Supreme Court hearing, the appeal, however you want to, whatever the hell, man. Shit, it's going to come up. Y'all go ahead and check this out. Let me know your thoughts and opinions. I think it's another clip that's going to come up before that. But if not, it'll be straight to the point with the appeal. So yeah, anyway it goes, y'all finna see it. Let me know your thoughts and opinions. We're gonna talk about this and RP to him if he did lose his life. I hope he didn't. If he did live, I wanna send my love and gratitude, and I just hope that you can flourish in life. If not, man, RP, and I hate to happen to you, man. Real talk. I'm gonna holler at y'all later.
Let's check in now with Fox 2's Laura Simon. She is downtown where a group against the death sentence will meet later today. Laura?
John and Blair, Marcellus Williams is likely in his final hours as Governor Mike Parson says that execution will move forward tonight. And this all comes despite an overwhelming amount of support from people across the world. And on Monday, attorneys made their final arguments for Marcellus Williams out at the Missouri Supreme Court. Williams is set to be executed today for killing former Post-Dispatch reporter Felicia Gale back in 1998. The 55-year-old has always maintained his innocence. He was convicted officially in 2001 for stabbing Gale to death 43 times inside her home in University City. He's been on death row for years at this point. His execution has been stayed twice. Earlier this year, St. Louis County prosecuting attorney Wesley Bell's office filed a motion to vacate the conviction based on DNA evidence that wasn't available when the murder happened. Questions came up about the integrity of the DNA because of the way the knife was handled by investigators years ago. Other issues also came up about the jury's racial makeup in Williams' original trial. Judge Bruce Hilton held an evidentiary hearing on Bell's motion last month, but denied it, allowing this execution to move forward. Bell sent out a statement on Monday saying, in part, even for those who disagree on the death penalty, when there is a shadow of a doubt of any defendant's guilt, the irreversible punishment of execution should not be an option. A clemency petition with more than 1 million signatures is set to be delivered to the governor's office today, but Parson has emphasized that courts at all levels have upheld Williams' conviction. Among the names on this petition, though, are victims' family members, and Michelle Smith is with the group called Missourians for Alternatives to the Death Penalty. Take a listen.
People who think, they're doing this for the family, please understand and reconsider your thought process in that, because in this moment, the family is not supportive of this. However, the government is still pushing forward, which is very disrespectful to the victim's family.
Advocates for Williams are scheduled to meet here at the Carnahan Courthouse at 3 this afternoon, and other advocates will be meeting in various places across the state, and many of those people are going to be traveling to Bonne Terre, where Williams is set to die by lethal injection at 6 tonight. Reporting live in downtown St. Louis this morning, Laura Simon.
Marcellus Williams is set to be executed today, but supporters are still hoping that Governor Mike Parson will change course.
Let's check in with Fox 2's Laura Simon. She is downtown, where those opposing his sentence will meet later today. Laura, what do they hope to accomplish?
John and Margie, I'll break that all down here in a second, but Marcellus Williams is set to die by lethal injection in less than 10 hours, and Governor Mike Parson says this will move forward tonight, despite the fact that there is an overwhelming amount of supporters who want to save Williams' life. This is not only a nationwide support system, there is a worldwide support system. And yesterday, out at the Missouri Supreme Court, attorneys made their final arguments in the courtroom. Williams is set to be executed today for killing former Post-Dispatch reporter Felicia Gale back in 1998. Williams is now 55. He has always maintained his innocence. He was officially convicted back in 2001 for stabbing Gale 43 times inside her home in University City. He's been on death row for years at this point. His execution has been stayed twice, and earlier this year, St. Louis County prosecuting attorney Wesley Bell's office filed a motion to vacate the conviction based on DNA evidence that wasn't available when the murder happened, and questions also came up about the integrity of the DNA because of the way the knife was handled by investigators years ago. Other issues also came up about the jury's racial makeup in Williams' original trial. Judge Bruce Hilton held an evidentiary hearing on Bell's motion last month, but denied it, allowing this execution to move forward. A clemency petition with more than 1 million signatures is set to be delivered to the governor's office today, but Governor Parson emphasized that courts at all levels have upheld Williams' conviction. Among the names, though, on that petition are family members of the victim. Michelle Smith is with a group called Missourians for Alternatives to the Death Penalty. Take a listen.
People who think, they're doing this for the family, please understand and reconsider your thought process in that, because in this moment, the family is not supportive of this. However, the government is still pushing forward, which is very disrespectful to the victim's family.
Advocates supporting Williams' plan to meet right here outside the Carnahan Courthouse at 3 this afternoon. Many of them will travel to Bonne Terre, where Williams is set to be executed at 6 tonight. Of course, we'll keep you posted if anything changes. Reporting live here in downtown St. Louis, Laura Simon, Fox 2 News.
That's why it would be appropriate to remand this back to the trial court and ask for Judge Hilton, who is in that courtroom, to issue these findings of fact with respect to all these issues. And what I would also note, Your Honor, is on top of Judge Sippel's ruling, what we saw then over the weekend is that Judge Kelly in the 8th Circuit said that she was extremely troubled by the exact same conversation that occurred. So I don't think that, Judge Sippel's argument is really going to be with the deciding factor here. The important part, Your Honor, is that with respect to the Batson violation, what happened is once the trial prosecutor was placed under oath and subjected to cross-examination, he said the quiet part out loud. He admitted that there was actually a racial component here, and that is unconstitutional. When this court issued its original ruling, the court's wording was very, very careful. It said, when the trial prosecutor had said that they just looked similar, there was nothing, quote, overtly or, quote, inherently racial about that. Now, it has become overt. It was expressly stated that there was a racial component. And that is what is so important here. And I think that there's a reason that you don't see that in the Attorney General's brief. Is they really don't want to address the actual statements that were made. He said he struck a juror in part because he was a young black man with glasses. That is unacceptable. We cannot stand for that. Just because we're hearing about it 1 month before an execution date doesn't mean that it's too late. That is the entire purpose of 547.031, is it allows us up to the last moment to come back and correct an injustice. This was a bipartisan bill that was passed by the General Assembly and signed by Governor Parson. This is not activism. This grants the right to every single local prosecutor in the state of Missouri, when they see an injustice, to come forward and correct it. That's what happened here. This is a trial prosecutor where this is not his first Batson violation. Judge Ross, when he was still a state court judge and before he became a federal court judge, also found that this trial prosecutor had committed a Batson violation in the McFadden case. This is not the first time. Also, we have the trial prosecutor's notes from this trial, except for one component of it, the voir dire notes. That is incredibly suspicious. And that is one of the reasons that it led the prosecuting attorney's office to bring this. Because this is someone who had a history, and what we've now heard is that everyone's worst suspicions were true. There was a racial component of this. Another important part about this is, in the years since this court issued its original decision in 2003, there's been a lot of development on the Batson issue within the U.S. Supreme Court. What we're now seeing is, this is an example where the trial prosecutor had already struck 5 of the 6 black jurors with peremptory strikes. That's the same issue that this court later saw in McFadden. It's the same issue that the U.S. Supreme Court has later seen in cases like Flowers, where the sheer number of peremptory strikes being exercised itself is an incredibly important indicia of whether there was a racially motivated. But you don't even have to get there because he testified to it under oath.
Mr. Potts, if I could interrupt you just for a minute, please. Is it my understanding that that you and Mr. Bell conceded the actual innocence claim at the trial court? That you did not proceed on the claim of actual innocence that was filed originally?
Your Honor, that's correct. The prosecuting attorney's office, based on the development with the DNA evidence, did not press the actual innocence claim further. And what ended up happening was, at the last minute, because everyone was frankly pretty shocked about the DNA findings, is that it was amended to add the Youngblood claim. I don't think that the actual innocence claim was formally deleted from the motion, but it was not pressed as grounds for relief. So
and you didn't make any findings in your proposed judgment as well regarding actual innocence?
Correct, because what had happened based on the Youngblood claim is, as I said, everyone frankly couldn't believe it, because you had this same trial prosecutor who's admitted that he's struck at least one juror in part because he's black, who said that he handled the murder weapon not once, not twice, but 5 times before trial without gloves.
Were those incidents, though, after the item had come back from the lab?
Yes, Your Honor. I think it was within a matter of 10 days of the murder being committed which was multiple years before the trial, is when he said he thought he was allowed to start handling the evidence at his will, based on what his theory of the case was. And we think that, and that's why we believe that that is bad faith. Trial prosecutors don't get to decide what happened. You have to follow the evidence. You don't get to decide what occurred and make decisions that you're going to handle a murder weapon. I mean, this is the knife.
Certainly not today, but what was known about DNA evidence was different in 2001, wasn't it?
And, you know, and I'll gently press back on that. DNA was well known. To give you a context, CSI was already out in terms of the television show. Everyone knew about forensics. There had already been a reversal in the St. Louis County Prosecuting Attorney's Office in 1996 based on DNA evidence. I see my time is up for the moment.
You can finish answering the questions.
Yeah.
Go ahead.
And so, Judge Ronnie, so to continue, DNA was incredibly well known, and this was actually the exact same year when the Missouri General Assembly passed the Post-Conviction DNA Act. It took effect, I don't know, maybe 2 months after this trial actually occurred. We weren't in the dark ages on DNA. This is something where everybody knew about DNA, and the General Assembly was passing legislation about it. Thank you.
Thank you, counsel.
May it please the court, I'm Michael Spillane. Let me correct some things. The prosecutor was not cross-examined. He was their witness. He was examined on this point on direct. What did he say when asked directly, did you strike someone partially, was part of your reason for striking someone because he was black? He said, no, absolutely not. Absolutely not. And he explained that that would be a violation of Batson. What they did, and I think you can read the transcript and follow it, is just kept asking him little snippets of questions from the trial court record, not letting him make a full answer, and then waiting for a spot where they could say, gotcha. But he did not admit that he struck a black juror partially because he was black. He said, no, absolutely not, absolutely not. And the district court where we did this last week looked at that transcript and said not only are they mischaracterizing the record, you can't even draw an inference from that record.
And didn't the trial court in this case, didn't the trial court make a finding that the prosecutor denied striking the juror because of their race?
Well, he didn't, but it's in the transcript. I mean, he made 3 findings. One of them, he said the prosecutor denied broader striking people because they were African American. He said that this court had already dealt with the same issue. And a third finding, which I don't recall, but it was not specific to this juror, you're right. But then the case law, which is in our brief, teaches that if a finding doesn't address something, you make the finding in accordance with the decision. So that said, there's no clear and convincing evidence here. There's no evidence at all. And it is the same thing on the young blood spoliation. The prosecutor testified and the judge found him credible that he never heard of touch DNA until 2015. This was 2001. He said the practice in the prosecutor's office was, after all the testing is done, you handle weapons without gloves because there's no reason not to. And their expert didn't disagree with that. Their expert was talking about testing in labs at that time, where they go to the lab and they test it, and of course they wear gloves. When she was asked on cross-examination, do you know anything at all about the procedures in the St. Louis County Prosecutor's Office at this time? Her answer was no. So she helped us on that.
Is touch DNA different than regular DNA testing?
Yes, I didn't mean to talk over you, but regular DNA, which the prosecutor's office used at that time, was fluid. Touch DNA is if you hold a gun or a knife and some of your skin cells, perhaps a very small amount, are on it, then you can magnify those, and there's a procedure to make enough of it to test. But the prosecutor never heard of that in 2001. His testimony was he heard of it in 2015. I mean, kind of off the record, I believe it existed in Europe in the late 90s, maybe 1997, but there's no evidence in the record that anybody in St. Louis had ever heard of it. So there was no reason to touch the, to wear gloves on the knife, because as the prosecutor said, there would have been no point in it. And we know he wasn't trying to destroy evidence because we know there were fingernail clippings. And he was very careful that those could still possibly be tested in his beliefs. So he said, I'm not going to open this package without wearing gloves because I don't want to contaminate it. So he wasn't trying to contaminate anything. As far as the fingerprints that they talk about, their brief refers to bloody fingerprints. There were no bloody fingerprints. There were fingerprints, and there was testimony at trial from the fingerprint examiner that we destroyed fingerprint lifts that were unusable because we couldn't compare them to anything. They're unusable, that's what we do. That isn't bad faith destruction of evidence. Something else they said, that the reason they brought the case was because of the prosecutor's notes that were missing, or part of the reason, if I understood them correctly. If you read the testimony of their investigator, it's the last one in the transcript, he said, we went down and got the file out of the locked vault where it had been locked up for years in February 2014. They brought this case, February 2024. They brought this case in January 2024. They brought this case by looking at this court's decisions and saying, we can attack that one. But they did not go and actually look at their own file for another month. So to say that that's the reason they brought this case doesn't fit with the testimony, and I'd invite you to look at the testimony of their expert. Before I move on to other things, are there any questions on that bit? All right, I would just say this, the standard is clear and convincing evidence, which is evidence that instantly tilts the balance in the favor of the proposition they're offering against all the other evidence. On those two claims that they've mentioned, there's no clear and convincing evidence. There's no evidence at all. And I think the judge is kind of a hero here because he stood up and followed the law. And I would say that about the prosecutor. There are all kinds of things saying bad things about the prosecutor, that he deliberately in bad faith destroyed evidence, that he struck people because they were African American, and that's in the briefs, and it names him by name. But that's just wrong. He didn't do that, and he shouldn't have his reputation trashed for this without any evidence at all. I will talk a little bit about jurisdiction. I'm not sure there is any. I think you've read our jurisdictional statement. 511020 talks about if something disposes of all the issues in the case, it's a judgment. Here we've got it denominated as a judgment. It's dated, it's signed, and it disposes of all the issues. So I think this is a judgment that isn't final yet. So that's something the court will have to deal with. Maybe it could address the merits in the context of the stay, but I'm not even sure the case is before you. As far as preservation, your court has read the briefs on preservation. Their brief has managed to unpreserve the issues that they had preserved. Everything they have is unpreserved. The first point relied on Batson doesn't say anything about a Batson error. It talks about the form of the judgment not addressing X, and then it goes into, in the body of the text, part of the argument is, well, the merits of the Batson violation. But that's not in the point relied on. So the argument is multifarious. The part that's in the point relied on was never raised below. They could have filed a motion, as they're required to under Rule 78, to say we didn't like the judgment. They didn't do that. So the part in the point relied on isn't preserved, and the Batson itself isn't in the point relied on. So, I mean, they managed to unpreserve that. As there's a similar thing with the Youngblood, because the Youngblood is multifarious in that it raises both the fingerprints and the knife handle. So that's not preserved. And then the third claim is the point relied on only talks about the time, the 4 hours that they had and the 2 hours that I had, but it doesn't say anything about the time as far as months or how long it took that they had to prepare for trial. So that's not in the point relied on, but more importantly, it was never raised at the court below. If they wanted to have more than 4 hours, you can read the transcript where I got up before opening statements and made objections to things I didn't disagree with. They didn't do it. They didn't say anything. Apparently they agreed to the 4 hours. And then they lost, and now it's like, oh, the trial court committed error by limiting us to 4 hours. Well, it's wrong to not tell the trial court that and then say, oh, the trial court is bad. It shouldn't have done that. The trial court did not violate their rights at all, and certainly not their due process rights. Did the court have any questions about that?
Counsel, on the third point about the length of the trial, doesn't the record reflect that neither side used the full time allotted?
That's exactly right. I believe, and I didn't take notes, one of the attorneys that was with me did. I believe I had, I don't remember exactly what I had, but I remember the prosecutor had, I think, 13 minutes, and Mr. Williams had, I think, 27 or 37. It may have been 37. So that would have been a total of 50 when they went to closing arguments. And nobody jumped up and down and said, I need more, I need more. This is just working back and trying to find error. And there isn't any error there. And as far as saying they didn't have enough time, they brought this case in January 2024. The district court on 6/5 in June 2024 set a scheduling conference. They didn't do a doggone thing. The plaintiff has the duty to pursue a case. That's why there's a whole body of law about dismissal for failure to prosecute. But they didn't do a doggone thing. They waited until the judge set the hearing, and then now it's like, oh, we didn't have enough time. Well, maybe you should have done something in the first 6 months that the case was sitting there and you were doing absolutely nothing. There's also a statement in there that I promised to do an answer or something. If you read the notice of intent to oppose that I filed in February, it just said the Attorney General's office intends to oppose this proceeding. It doesn't say I'm going to file an answer. There wasn't anything that I could really do until they prosecuted the case. I guess I could have filed an answer, but I don't have to prosecute it for them, and it's not my fault if they wait until the last minute, which they did, to put this case in front of this court the day before the execution. They should have done better than that, but it's not the court's fault, it's not my fault, and they also criticized this court for setting an execution date under 3030 when the case was pending. Well, this court followed the law. 3030 says when you set an execution date what the requirements are. And you didn't do anything wrong by following the law. The judge didn't do anything wrong by handling the case the way he did. The prosecutor didn't do anything wrong by touching the knife when there was no reason to believe that there was a reason not to touch the knife. And the prosecutor did not make any strikes that were partially based on race. The argument that they made in their motion to vacate is exactly the argument this court rejected in the direct appeal opinion, which was it's race-based because they look similar. And this court discussed that and said, no, it is not race-based. And now what they've got is he used the word brother instead of they just look similar. He said they look like brothers, and they say, that is an admission that the strike is race-based. No, it's not. It's the same thing he said that this court reviewed 20 years ago, just with different words. And when they actually asked him the question, it was no, absolutely not. I did not strike him because he was, in part, because he was African American. That's what the record says. And what the district court said, which they don't like, but the district court who reviewed this last week said, not only is that a mischaracterization, you can't even draw an inference from this record that it was race-based. And it isn't drawing an inference, it's proving it by clear and convincing evidence. They didn't prove it by any evidence, certainly not clear and convincing. Probably I should ask for questions again. I don't want you to go away not having me answer anything you want to know. All right, I would just say this. Nothing they have is preserved. I don't think this court has jurisdiction to hear the case, but I would ask that you write an opinion that addresses the merits of these issues ex gratia, or however you want to do it, so that you can do it in addressing the state, because I think that's important. And if you could find your way to say that the prosecutor isn't Satan, I'd appreciate that too.
Thank you.
Thank you, counsel.
Counselor, do you agree that neither you nor Mr. Williams used the time that the court allotted for you for the hearing?
No, there's no dispute that the full amount of time wasn't used, but that's also because you have to make strategic decisions based on the amount of time that you're allotted and whether you can call the witnesses who you want to call. For example, Mr. Williams was going to be testifying likely for an hour to an hour and a half on there. There was no opportunity to actually put him on the stand because of the limited amount of time that was there.
So between you and Mr. Williams, there was 4 hours allotted, and then the state was allotted 2 hours, is that correct?
To be clear, there was 2 hours for the prosecuting attorney's office, 2 hours for Mr. Williams, 2 hours for the AG's office, Your Honor.
And then what about the fact that you filed no 7807C motion? I mean, this court has case law, regarding the juvenile cases where there's a requirement by statute, not necessarily even, requesting findings of fact. Even in cases where the statute requires you to make findings of fact, if you think one was presented that wasn't found, you're required to bring that to the trial court's attention.
I'm glad you asked that because I have a couple different responses to that. The first one is the issue here is that the court didn't reach the merits. This isn't about the form and language. It would be about the form and the language if the court had actually reached the merits of the Batson challenge.
But didn't they read, the court made a finding that the prosecutor denied striking jurors because of their race.
So Judge Powell, that is not what the finding is, if I can gently push back on that. That is at most a summary of testimony. And all that summary of testimony says is that he denied systematically striking black jurors. All that Batson requires is the striking of one black juror. That is clear under Flowers and all the U.S. Supreme Court's precedent. So it's non-responsive to the issue at hand, which is whether juror number 64, who said that he was willing to impose the death penalty, provided no pushback to that to the prosecutor whatsoever, and should have been an ideal juror, except for the fact that according to the trial prosecutor, he was a young black man with glasses. That is unacceptable under the Constitution. With respect to the jurisdictional issue, I also wanted to say the court should be, I think the court clearly has jurisdiction. It would create enormous problems. Think about ballot measures, just thinking about last week. If we're going to deprive this court of jurisdiction just because something's on an expedited basis. The court has jurisdiction over a judgment. The finality rules, that refers to the triggers that will relate to everything else. And with respect to the inability to, address the form and language, Your Honor, we can't be put in a catch-22. There's no way that we are going to have the time to actually come and brief this before this court. We're already here on Monday morning before the day of execution. There's no practical way. With that, what we would respectfully request is that the court would either enter judgment with respect to the trial prosecutor's motion, or alternatively, send this back to Judge Hilton so that he can make the actual findings that are necessary for this Batson claim so that this court can review it. We thank the court for its time.
Thank you, counsel. The matter will be taken under submission. The court will be in recess.